Hello, and welcome to Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, Director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Thursday, March 26, 2026. And if you have been waiting for the Short Circuit, where you get to hear about your favorite circuit, then today is that day. Unless your circuit is not one of the favorite circuits picked by our guests. But we'll find out all of that in a little bit. The backstory on this episode, which is going to be the second half, the special part will be the second half of this episode, is that I, a while ago, did a couple interviews of a couple brilliant legal academics to ask them about their favorite circuits. And so we discussed those circuits. And then I had a project where I was going to keep doing these interviews of different folks, and travel would either be weird, or I didn't set it up in time, or I forgot the equipment, and a whole list of excuses as long as my arm. And then the interviews got a little old. And so now we are finally using them, with huge apologies to the interviewees, which I will also be extending to them privately. But we are now adding another interview, which is my colleague, Ben Field. So Ben, in a little bit, will talk about his favorite circuit. Before that, though, we're going to do a regular old episode of Short Circuit and talk about a recent free speech case from the Ninth Circuit that some of you may find interesting. It has to do with speech via app to employees. So we'll get to that in a little bit also, and then we'll get to the favorite circuits, and then I have an update before all that. But first, I want to welcome Ben onto the show. So Ben, welcome back to Short Circuit.
Thank you very much. And I suspect that the plaintiffs in this case would not agree with you calling these people employees at all.
Right. Employee in the broadest sense of the word, which I should understand as a former employment lawyer. Independent contractor, I think, is their preferred nomenclature.
I think they would be very aggressive about saying that.
And the city of Seattle apparently thought differently, unsurprisingly, and so that is the rub of the issue. So we'll get to that very soon. Now, first though, we have definitely unintentionally, but also unintentionally uncovered a bit of a scandal. And so I am very excited to reveal this, that I did not know. My ignorance is going to show. I did not know this, and it has to do with the Fourth Circuit. So Ben, I will be curious, as someone who likes a bit of circuit gossip and scandal, I will be curious as to your thoughts about this. So we just did last week our edition of the 12 Months, 12 Circuits series on the Fourth Circuit. And listeners who heard that episode will remember we discussed how many judges are on the court, what states the Fourth Circuit covers, a few other fun facts about the circuit, and where the circuit holds argument. Now, I didn't do a heck of a lot of homework for that episode. I will say I went to the Federal Judiciary Center, I think, for some of the information, and I just read off what I read, and this gives you a sense of how careful we are on Short Circuit with our special knowledge. And I read off that the Fourth Circuit holds argument in Richmond and Asheville. Now, Richmond I knew about, and I've heard about, unlike how a lot of circuits do their oral argument, for en banc arguments at least, the Fourth Circuit has this big court week where they go to Richmond, and there's like all these they get their en banc hearings done at once. It's not ad hoc. And so I knew all about that, but then I just read off, also Asheville. And then I apologized, and I wasn't even sure if Asheville is in North Carolina. And then my other guests told me, yes, it is in North Carolina. Well, then I heard, though, after that episode came out, from someone who is connected, has a history with the Fourth Circuit. And this uncovered something I had no idea about. That is that, yes, Richmond and Asheville are set as places for argument in the Fourth Circuit. Now, what I didn't know is there is actually a congressional statute, 28 U.S.C. Section 48. Ben, do you know about this statute?
No,
this legislation?
I usually spend, every night before bed just reading through the U.S. code, but I must have missed this
Yeah,
one.
you skipped over. You're like, that's the boilerplate stuff. Well, that's what most people would think. But actually, Congress has set, so Congress does, there's all kinds of laws Congress has passed that kind of regulate, you might say, the courts. And to some extent, they kind of have their inherent authority under Article 3 to structure themselves. But a lot of it is structured by Congress, as Article 3 allows. And so this section of the U.S. Code says the courts of appeals shall hold regular sessions at the places listed below, and at such other places within the respective circuit as each court may designate by rule. And then it gives, it's funny, it has a little chart, and it gives each circuit where they hold their places of argument. And so District of Columbia, Washington, first, Boston, second, New York, third, Philadelphia. And then it goes on, and then most of the higher numbered Western circuits actually have lots of cities because, they're geographically bigger, I guess. The Fourth Circuit, it says Richmond, Asheville. That's it. That's the law. Richmond, Asheville. So I think that's why it's in the Federal Judiciary Center. That's why they list that. Now, here's the thing. There's another part of this, Section 48, that says, sub C, any court of appeals may pretermit. That's a normal English word, right? Pretermit. May pretermit any regular session of court at any place for insufficient business or other good cause. Okay, here's the backstory. Apparently, in the early 50s, a senator from North Carolina had Asheville added to this part of the code. Now, I think they might have actually had arguments at Asheville before that, but this kind of made it like, a regular part of the court. And the court back then was only 3 judges. So it's massively exploded since then as population's grown. I did a little research in the newspapers.com database. It seems they did have arguments in Asheville in the 50s. But then at some point, and this is what my source told me, at some point, the judges got tired of going to Asheville, and they just wanted to go to Richmond in Virginia, and they stopped holding this. And they haven't had an argument there in decades now. So they always just have this excuse that they don't have an argument there. But I guess there is a courtroom at the Asheville courthouse called the Court of Appeals courtroom. It's just never used by the Court of Appeals. And so if you're, a practitioner in that part of North Carolina, you're probably like, what gives? Like, they never have argument here, even though Congress has said this is your place of argument. So apparently there's a little bit of tension on the Fourth Circuit, but they just keep going to Richmond, and that's the way they do it. So that leads me to think, what else is going on in the other circuits? But I haven't dug into that, but maybe when we do the other circuits, we'll see if they actually go where Congress has told them to go. So I don't know if you think that's scandalous, Ben, or you're like, who wants to go to Asheville? But it's a beautiful place. It's up there, kind of higher elevation, and
Oh, I'm just recovering. I managed to get my smelling salts to revive myself from the scandal that you just shared. But no, if I were, I like Richmond, it's fine. But if I were a judge, I'd probably like to get out into the mountains, see the Biltmore, go to some breweries. In Asheville, they just got that big hurricane, so they could use a little love from the federal judiciary to help them out.
That's true. Well, I appreciate the sarcasm, but I will say they like a lot of circuits, they have a conference, and it looks like in the 50s they often had their conference in Asheville in the summer, which is not surprising because most people don't want to be in Richmond during the summer. The stifling, if you ever read, Civil War history, that's not a great place to be in the summer, even when there's not a war on. But apparently that's not the way it is anymore, at least for oral argument. So we will move on from scandal to our regular short circuit fare. So Seattle, a place where I grew up in the Seattle area, I know it well, and I don't know it well in terms of taking an Uber, because that was kind of before my time. But apparently these days there's some extra speech between Uber and the people who drive for it. I'll just leave it at that. and that may pose a constitutional problem. And so, Ben, explain how that works.
Sure. So the case is Uber Technologies versus City of Seattle. And as you said, this is a case about folks who work for specifically Uber and Instacart, though it's not actually the rideshare drivers. It is the folks who do courier services.
So it's just Uber Eats or the Instacart stuff.
Exactly. So, some people like these, gig economy things, and, some people don't. So just to editorialize, I think Seattle decided they were going to do one of the stupider laws I've heard about, which doesn't necessarily make it unconstitutional. Justice Scalia famously had a stamp that said, stupid but constitutional. So we'll figure out whether it's constitutional or not in a bit. But just to lay the groundwork, the Seattle was apparently concerned about instability in the gig economy. And sort of the whole point of these jobs is that they're gigs, and so people can pick them up and drop them as they wish. And as the flip side is that they can be hired for, just one gig or not. But Seattle wanted to sort of force them to be more like employees than like the independent contractors that we were talking about. And they were specifically concerned that people might be terminated from these apps arbitrarily. And so they passed a law, and we'll get into some of the details as we go through the constitutional claims. But basically, it required that these companies have come up with this set of policies for when people would get terminated from the apps and create sort of a Baroque internal appeals process to whether or not you get terminated from the apps.
Yeah, it's kind of like protections. So it's not just at-will employment, for lack of a better other term, even though it might technically not be an employee.
Right. And obviously it wouldn't work. Certainly if Uber wanted this to go the other way, where like employees could not leave them unless they inform them why they were quitting Uber and went through an appeals process and made the requisite fact finding. I can't imagine anybody would think that's a good idea, but apparently the other way around is totally fine. And they had some rules on what these policies were allowed to be. And so, I'm just curious, Anthony, if you were a consumer of an Uber Eats driver, would it be a value to you to know whether the person has 2 stars or 5 stars?
It seems like everyone has 4.9 stars in that universe. So if they had 2 stars, I think I would think twice about that delivery.
Yeah, well, the city of Seattle doesn't think you're allowed to make that decision. So people can't be kicked off the app for low customer ratings alone. If there was a background check that revealed that person had a sketchy history, unless it's one of a series of specifically defined, particularly bad conduct, background check, no good. If, they have their driving record apparently is irrelevant to whether they are a good employee, as is their history of traffic infractions. Again, unless it rises to a certain predefined level. So apparently all of these things that seem like they're pretty relevant to the job of being a delivery driver, Seattle doesn't think those should be in the policies.
How bad of a driver do you have to be before it's relevant then?
There's a definition of egregious misconduct in the statute, which the court does define. And it includes some things like you would expect. If you're physically endangering somebody, that's apparently egregious. So Seattle's willing to say, yeah, you can kick someone off if they're, threatening.
So maybe a reckless driving ticket.
But it shall not include non-criminal moving violations or traffic collisions, unless you have 3 in the previous 3 years. So if you're getting into just 1 crash a year, you're good to go. So that's my largely editorializing about, I think, the silliness of, largely Western cities, micromanaging everybody's day-to-day lives. But Uber brought this lawsuit on two, you can't just say this is stupid to a large extent. Obviously, we are trying to make it a little bit easier to say this is stupid and to bring a claim. But for better or
But
worse,
they don't try to do that. They don't go the IJ
No.
way of rational basis attack and all that.
Right. So they have sort of two more surgical claims. And so they say, one, that this is too vague, and second, that it violates the First Amendment. So I'll just knock vagueness out pretty quickly. None of the judges think that there's a vagueness problem. For better or worse, there's like a background rule under due process that laws can't be vague because it would violate due process for you to be punished for a law that is impossible to know what it demands. But the standard is pretty low. And the problem here is like the statute defines things in terms of reasonableness, and courts do things in terms of reasonableness all the time. So the judges are like, we do it.
Yeah.
Uber can figure it out too.
If reasonableness was too vague, we kind of wouldn't have any law, unfortunately.
Exactly. So they say it's not vague. So the more interesting claim that gets more attention, and this is up at a preliminary injunction stage. So Uber asked the district court for a preliminary injunction to stop enforcing the law. It was denied. It goes up to the Ninth Circuit. And Uber says, okay, the other problem is that we're being compelled to talk about this policy to, our contractors / employees, or however you want to characterize them. So they say, look, but for this law, we would just prefer not to write policies like this. But you're forcing us to write these policies and to communicate them to the drivers. And so that's a violation of our free speech rights. And the Ninth Circuit, the majority of the panel says, actually, that's not speech at all. That it's really just sort of incidental to trying to regulate the relationship between the drivers and and Uber and Instacart. And so, yes, you're doing a lot of writing and you're doing a lot of speaking, but don't worry, it's not speech. So perhaps predicting that this is not the most compelling argument, in the alternative, the court also says, okay, so if it is speech, we'll do First Amendment analysis on that. And they apply a form of intermediate scrutiny that's based on a case called Zauderer. And that has to do with disclosures. And so if a law requires disclosures in commercial speech, then it has a lower sort of standard of scrutiny than, a content-based speech regulation that's trying to regulate political
And this
speech.
usually comes up with warning labels on food products, that kind of thing, right?
Exactly. And so these are things that we generally, people are used to all the time. So that, you go to the grocery store, you pick up your box of Wheaties, it has a nutrition label on the back. The reason the government is allowed to require them to do that is because of this Zauderer standard that you can require disclosures. But what Zauderer requires is that the disclosures have to be purely factual and uncontroversial. So, in the Wheaties example, it has X bajillion calories. That's factual. Maybe it's controversial to your waistline, but it is what it is. And it also has to relate to the service so that you can't. There was a famous case, a couple of years ago where, crisis pregnancy centers who their whole thing is that they don't like abortion. They're trying to help women find alternatives. California was essentially trying to force them to advertise abortions. And the Supreme Court said, okay, that's not both that's not uncontroversial, and second, that's not really directly related to the business that you're involved in.
And it's not incidental either, right?
Exactly. They said a lot of other things that we also like, but for the Zauderer part, that was kind of what they said. And it also can't be, these disclosure requirements can't be unjustified or unduly burdensome. So in prior Ninth Circuit litigation, I think the city of Berkeley required these insane disclosure requirements on political speech where you had to disclose everybody who supported the speech, and it took up half of the billboard or the advertisement or whatever. And so there was litigation over whether that was too burdensome. So that can be another part. And what the court says, but often this really, like, the Zouderer thing comes down to, is it is it just requiring the business to like give people basic factual information, or is it like, is this really trying to put the government thumb on the scale of getting somebody else to say things that the
Right.
government wants them to say? And in this case, the majority says, no, it's more like the former, that they're just saying, like, there's a law that requires, at least as the majority reads it, it like says you can't terminate people if you don't follow one of these if you don't follow a policy that complies with our rules, so that, you're not allowed to fire them if they're just a terrible driver, who are, making rude comments to the customers, and that's not good enough. And, they're so bad that they only have 1 star when everybody else has 4.9. So they say, like, you're not allowed to, we're just regulating that employment relationship or that contracting relationship. And this is just an accurate statement about what that relationship is allowed to be or not allowed to be. And so the majority thinks it's a pretty straightforward case of just, a normal disclosure, just like telling the calories on a Wheaties box, or a pharmaceutical company having to tell you what the side effects to their drugs are.
Right. Or they bring this up a couple times, or informing you of your rights, as is done in many other employment contexts. Like, we've all been probably in a workplace where you go in the break room and there's a poster that says what the minimum wage in the state is. And, most people are making more than that minimum wage, but that it's up there because there's a state law that says that needs to be displayed in a workplace. It seems like the majority is just thinking, like, is there a First Amendment problem with that? No, everyone's just super used to that. This is just the same thing. It's just via app.
Right. And to your point, they say, like, okay, maybe there's like some discretion in the actual, like, creating the policy that you're communicating. But once you've made that policy and you're communicating it to the drivers, as the majority opinion says, well, then it's just literally true. Like, once you've made the policy, it's just like informing your employees about the minimum wage. It's like, that is the policy.
Everyone has a handbook of policies. So it's just that.
And so that's the majority. And they don't think that this is that big a deal. They say no preliminary injunction, and the way it's written, it seems pretty clear that Uber just loses on the merits. But the dissent, Judge Bennett, he thinks that this is a weightier issue than the majority does. So first of all, he says, okay, guys, this is just obviously speech. You're like forcing them to, write down something and to communicate it to the drivers. This is speech. Don't be silly. And I think that's just obviously true. I mean, the reason we have doctrines about commercial speech in Zouderer is because, like, they are speech. They wouldn't if those weren't speech, we wouldn't have to have those doctrines.
It's odd that the majority does. I mean, they have an alternative holding, but they do spend a chunk of time on it's not even speech. And then they go, whereas usually a court would say, well, we're just going to assume from the outset it's speech, and then they deny it anyway. You almost get a sense maybe they rewrote it, because there's a lot of footnotes responding to the dissent here too, way more than you see normally in a back and forth in an opinion. And so I wonder if there was a good bit of rewriting at some point.
Yeah, I wouldn't be surprised. The footnotes are often like pages long.
Yeah.
So that
and
you're like in
font.
the tiny font under the line that's going on for a couple pages. So I think you're right that it kind of smacks of that. And like usually this line between, is it speech or is it just like, is it not? Usually we're talking about things like the canonical case at the Supreme Court level is like burning a draft card. Is that speech? In the course of, like, it's not speech. It's like it's a way to protest, but the actual act of burning the card is non-expressive conduct, even if it has something. I mean, that's just like miles away from like having to write something down and communicate it to your employees or contractors. So once Judge Bennett has said, guys, this is obviously speech, let's move on. He has some interesting points on why he doesn't come come down on it definitively. And maybe this is why the majority went there, is that the district court's rationale was that this just wasn't speech altogether. And so it didn't bother getting into the details of the Zauderer analysis. And so Judge Bennett in dissent says, I would remand this to the district court to do this sort of fact-bound analysis in the first instance. But he says, I think that this is a weightier question than the majority would suggest. And he gives a few reasons on that. So first of all, he says, like, it's not clear that this really is factual and uncontroversial. As my joking has been suggesting, like, people might very well disagree about whether it's appropriate to fire somebody or kick them off an app because they're a terrible driver or get terrible ratings or engaged in various other criminality. And so it's not uncontroversial to have to write these kinds of policies. And so I think like that's just getting at an intuition that, this sort of is shading more, as we were talking about, Zauderer is about, are you just like telling people basic facts about the world, or is the government trying to use you as their mouthpiece to say something controversial? And if you're being forced to articulate, like, I believe that, I shouldn't be cutting people off for all of these reasons, it does shade a little bit more into the government trying to turn you into their mouthpiece. But then I think the most fun thing that Judge Bennett has is that, there's going back to this like idea of it being literally true. The majority's view is like, this is really just the law is you're not allowed to kick people off the app for these reasons. And all we're doing is requiring you to communicate that truthful information to the drivers. But Judge Bennett actually reads the law. And as is sort of often the case with these populist laws that are more concerned about virtue signaling than about actually solving a problem, it's not particularly well written. And so what Judge Bennett says is like, if you just read the law literally, it seems to say you have to have a policy. And then there's another section that says you're not allowed to terminate people except like consistent with the section that requires that you have a policy. But there's not actually a provision that says you can only fire people consistent with the policy. So he says, like, you have to have a policy and you have to have an investigation to see whether someone complied with the policy. But there's not actually a prohibition on firing somebody for reasons outside the policy.
Then what is the language in? So I admit I did not read the text of the ordinance as quoted as closely as you did or Judge Bennett did. What is the actual mandate or the language about how, you can be a terrible driver and not get fired? Like, what does that do?
So there are two parts. So the actual provision that bans firing people just it incorporates by reference the provision about the policy on deactivation. And what the policy on deactivation requires, Section 1 requires notice. So that's the communicating to the drivers. Section 2 describes what a reasonable policy is. And that's where it sets out these examples of things that you can't your policy isn't allowed to be. Section 3 requires an investigation for any before terminating people. But there's not actually a provision that says you can't fire people for reasons outside the policy.
So you can have a policy say, our policy is we don't fire you just because you're a terrible driver. And then you have to communicate that to them. But then later you can fire them for being a terrible driver.
Well, I mean, it's at least ambiguous. So you have to, and if you fire them, you have to do an investigation of whether they complied with the policy. But if at the end of the investigation, you're like, actually, you were fine with the policy, but we don't like the red hat that you're wearing, and we're firing you for that. There's not actually a provision of the statute that forbids that. And so what Judge Bennett is saying is like, actually, this isn't incidental to regulating the employment relationship. This really is much more about, at least as written and as he interprets it, this really is just requiring people to tell people about a policy that has no legal effect, and that's speech, and that's compelled speech. And another interesting point that he has is that it's actually for Seattle's not actually allowed to enforce this until 2027. Like, they're not allowed to enforce the terminations. They're only allowed to enforce having the policy. And so what Judge Bennett says is like, well, at least for the first year of this law, there is no like actual like regulation of the economic relationship. All that you're regulating is forcing people to tell this policy to their drivers. And so at least for at the beginning, this is entirely just a matter of speech. And so I think, obviously he's in the dissent, so it doesn't carry the day. But I think it's if nothing else, there's sort of a new term that's going around the internet, sloppulism. The idea that like a lot of sort of both on the left and the right, there are a lot of sort of populist policies out there that like aren't really thought through and are just about sticking it to somebody you don't like. And so I think like at the very least, legislators who are going to enact sloppulism should have a lawyer who's a little bit less sloppy read it through.
Yeah, you wonder if it was because it was sloppy, and it may well have been, or if it was because they didn't actually want this to really be legally enforced. They just want to do some signaling and scare, companies into being better. But to actually enforce that would, of course, at the end of the day, look bad. So maybe they protect themselves from that.
Yeah, and I think that's what Judge Bennett is getting at. The whole point of the Zauderer doctrine is like, as we've been talking about, is like supposed to distinguish between the government's just forcing you to like give people some basic information versus the government's trying to use you as their mouthpiece. And if it really is what you're saying, that like we really do just like want to stick it to Uber and force them to say things they don't want to say, well, then that does seem like it's a speech problem.
So I have a final question about this, which is people who know the whole commercial speech lay of the land may know that if you have content-based restriction on speech and it's not commercial speech, it's very strongly protected. Strict scrutiny you get if you're against the government. Then commercial speech, most commercial speech goes through this thing called the Central Hudson test, which is essentially advertising, and that gets this kind of intermediate scrutiny, which can, depending on the judge you get, it can be pretty protective. And then there's Zauderer for this disclosure stuff you're saying. I don't get how this speech, which is a communication from a policy to an independent contractor, is commercial speech. I don't get how it's commercial speech at all. It's not advertising. And classically, commercial speech is that, like they say over and over again, commercial speech is advertising. So that's why if you have occupational speech, like the cases that IJ does with a tour guide or a journalist, where your speech is your job, even though you're getting reward for that speech and monetarily, it's not commercial speech. So how is this commercial speech?
Yeah, I had the same inclination. The sort of the typical way it's phrased is that commercial speech is speech that does no more than propose a transaction. So it really is advertising. It's like saying, come buy my Wheaties for $2.99 or whatever. So Judge Bennett actually doesn't dispute that it's commercial speech. And I think if you were justifying it, what they would say is, okay, communicating this termination policy to the drivers is, essentially a way of proposing this employment contracting relationship with them. And so it's a form of commercial speech. I suspect that what's really going on is that, if they were to really delve into it, then the kinds of things you were talking about, like, posting Fair Labor Standards Act provisions in the company break room or something. I mean, that's not really proposing like someone who's been working at the company for 10 years and is like, has been there forever and maybe even has a long-term employment contract. Like that, posting in the break room isn't really proposing a transaction, but everybody kind of thinks it's okay to require that. So I think maybe when you're just in this quasi-employment relationship, courts think it's fine to require at least certain basic factual disclosures. And so they don't think too hard about it.
Right. And I guess in some ways, like any contract between two parties is speech, even if it's not an employment contract. But if there's all kinds of laws about what the contract can say in certain relationships, and that, the First Amendment just never comes up. there. I guess it's just considered conduct. So you can't think too hard about it. I guess maybe is the bottom line.
Right. I think this might be one where there's just enough water under the bridge that nobody wants to make it fit into the doctrinal buckets very cleanly.
Right. Well, we're going to get out of our doctrinal buckets and into our favorite buckets. So, Ben, I understand this is a little bit about asking a parent to pick their favorite children for you, but I'm just going to throw it out there. What's your favorite circuit?
So, the reason I think you say that is because I clerked for judges on 2 circuits, the Ninth Circuit for Deer Meadow Scanlon in Portland, Oregon, and the Third Circuit for Kent Jordan, who sat in Wilmington, Delaware. And so I love both of them very much, and I have great appreciation for both circuits. And just as a disclaimer at the start, I should say, like, the composition of both courts have changed a lot since then. Both my Judge Jordan is fully retired. Judge O'Scanlan is senior status and not really hearing cases anymore. So, nothing I say is an impugnment on them or even what the courts were like, are like today versus back then.
But with all that being said.
Yeah. So it has changed over the course of my being a lawyer. So I would say when I was, my first clerkship was on the Third Circuit the year after I graduated law school. And it was a fantastic experience. Things I really liked about it is that it's much smaller. The judges seem to really, really know each other. It's just Pennsylvania, New Jersey, and Delaware. So, Pennsylvania gets pretty big out there, but where the core population base is, you can drive around in a couple hours. So you actually, even just, in a 1-year clerkship, you kind of got a sense of who are these district judges, or at least what are the reputations of the districts. And so, it's a very functional court in that way. And the judges try not to, do crazy things. And so it works. And so it's sort of, as a lawyer fresh out of law school, it seemed this is what courts are supposed to be. This is a functional organization, and this is great. The Ninth Circuit, on the other hand, it is a very, very different animal. So first of all, it's just geographically gigantic. It covers the entire West Coast plus Alaska and Hawaii. So it is just super sprawling. It has 29 judges compared to the Third Circuit's 14 judges. So it's just way bigger than any other circuit in
plus
terms
senior
of number
judges.
of judges. And so the other thing is that the Ninth Circuit, that's really undercounting it, because the Ninth Circuit has such a large caseload that their senior judges are sort of more involved than in most other courts, in my experience. And they also import a ton of judges. So if you go and look at a Ninth Circuit sitting, almost every single panel will have a random district judge from somewhere else in the country or a senior circuit judge from another part of the country. So in practice, the Ninth Circuit has many more people than the smaller circuits do. And it has famously been very, very contentious. So, going back to sort of its heyday when you had Carter appointees and Carter appointees and Clinton appointees, just a constant war with Reagan and Bush appointees. And so, famously you had people like Judge Reinhardt who would flout the Supreme Court and say they can't catch them all. And then you had, he was sort of the big doyen of the Ninth Circuit. And you had, conservative judges like Judge O'Scanlan or like Judge Kaczynski, who would then be constantly dissenting from denial of rehearing en banc to beg the Supreme Court to fix what, the Ninth Circus was doing. So they just had very different personalities. And I think that the judges on the Ninth Circuit generally do like each other and kind of enjoy being part of this experience. But it was definitely a more feisty environment. And people writing back and forth would be more aggressive. The circuit email, the email list that the judges would all send to each other was much more lit, as the kids might say, than I think the comparable Third Circuit version was.
And then how was clerking different there in that you'd probably traveled to San Francisco or Portland or the various places that 28 U.S.C. 48A lists for the Ninth Circuit to sit. Was it more kind of meeting different people than you might have in Third Circuit where you get to know those people really well through the year?
Yeah, so perhaps unlike the Fourth Circuit, the Ninth Circuit does sit all over the place. In part because like it's so sprawling that like obviously it's much to force people from like Eastern Washington to have to travel down to San Francisco where the court is headquartered is more of a burden than having to drive from West Orange to Philadelphia. And so they do sit. So like they sit regularly in. So San Francisco is the headquarters, but they're sitting very regularly in Los Angeles. They sit in Seattle a fair amount, at least a couple sittings a year in Portland, Oregon, and then at least once a year there's a sitting in both Hawaii and in Anchorage. And so Phoenix sort of gets the short end of the stick somehow. And I think Arizona has always been the biggest proponent of splitting the Ninth Circuit because they're the second largest state next to California and they feel underserved. So Phoenix does not get as much regular treatment, but there are occasional arguments.
Well, not to mention Boise or Helena. I mean, the Idaho and Montana are basically forgotten about.
Yeah. So, but as a result, I mean, I think that like so as a clerk, it's a great experience to travel around. We had the great burden the year I was clerking that we got one of the Honolulu sittings, and so we had to sit in a resort in Waikiki, pondering the law very very deeply on the taxpayer dime.
Which sounds like it was well worth it.
But as your question was getting at, I think that in the Third Circuit, it's like the judges are just like they're always in Philadelphia together, and there are fewer of them, so they just know each other personally much better. Whereas in the Ninth Circuit, they're just spread out way more, and they're not all sitting in the same place all the time. They obviously. I don't want to suggest that they're not collegial, but like there's obviously a difference between seeing a colleague once every 2 years or once a year, at a circuit conference, versus seeing them every month or two.
So to closing question, which is a question I asked the other two guests, so people will hear from in a moment. What is your favorite Ninth Circuit anecdote?
So my favorite anecdote is unsubstantiated, but there are. So the Ninth Circuit, I think, has become a little bit less. Well, I don't know. So it went from the height of contentiousness when like the Carter appointees and Clinton appointees and Reagan appointees were all still at their peak. And it was that was, very, very famous era. And so my story will come from then. When I was clerking, it had sort of moved into sort of the Bush 2 appointees were a little bit lower temperature than the Reagan appointees overall. And the Obama appointees were much lower temperature than the Carter and the Clinton appointees. And so there weren't as many en banc cases, weren't as many en banc petitions. It was a little bit less aggressive. But since then, we've now had an influx of Trump appointees, and at least some of them seem to be trying to bring the old Ninth back. Particularly a certain judge in Nevada, who I believe you'll be talking about on another short circuit themed podcast. So but like back in the days when like, Judge Reinhardt was really having it out with people like Judge O'Scanlan and Judge Kaczynski, there were like just tons of conspiracy theories over how the court worked and like what the clerk's office was involved in. So one of the fun things about the Ninth Circuit is that they don't have real en bancs. It is theoretically possible for the entire court to sit en banc, but I don't think it's ever happened.
Yeah, I think it's literally never happened.
Not in the last several decades. Instead, they have limited en bancs, where if a case gets called en banc, the 3-judge panel opinion is vacated. But rather than all 29 active judges hearing it, they randomly draw 10 judges plus the chief judge to hear the case in a limited en banc. And so, as you can imagine, just as like for a 3-judge panel, a 10-judge panel can also, not necessarily reflect the entire 29 judges. And so it can be quite consequential who gets selected for it. And at least back in the way that the judges are picked is that they are literally like pulled out of a wheel at the headquarters in San Francisco, like a judge or a clerk, pulls names out of a wheel. And so I know that there were at least conspiracy theories on how panels continued to be selected that certain, not everybody thought was representative of the entire court. That like, I can't remember whether they were balls or slips of paper, but in either case, there were conspiracy theories that some of the balls or slips of paper were placed in a freezer beforehand so that a clerk reaching through would be able to identify the ones that had been selected. Again, I have no evidence that this is true, and it seems a bit far-fetched to me, but it's just the kind of thing that I know that clerks would have scuttlebutt about to theorize on how these things would happen.
Okay. Well, freezing the lottery.
So I have no idea, but people like to play those kinds of games.
Well, we won't disappoint listeners and try to disprove that conspiracy theory. We will leave it at that. And thank you.
You didn't force me to answer which one was my favorite, though.
Tell me.
So as I was saying, I think that the Third Circuit seemed like the perfect circuit when I was first starting out. But, after practicing for, over a decade now, I think the Ninth Circuit is the one that wins out in my heart. I think that, there's value to being, functional and just keeping the railroad moving on time. But I think that in practice, that can often, not rocking the boat, not trying to reach big constitutional issues, I think ends up having too strong a bias in favor of the status quo. And often that means in favor of the government. Whereas, the Ninth Circuit or now certain other circuits, which, I won't pick on, are a little bit more raucous. And they might get reversed by the Supreme Court a little bit more often. But I think that there's value in judges like actually giving each case its own best shot and allowing the law to evolve rather than just sort of being instinctively small c conservative.
All right. Well, we're gonna leave it at a high note of appealing to judges to be engaged, be a little raucous, rock the boat. Maybe there's some lessons to be learned too from the wilder side of the Ninth Circuit, but we thank you for that, Ben. And so for everyone, I would love for you to listen on to the 2 other interviews we have on this. So I interviewed both of these folks a couple years ago, I will admit, when I was on my book tour. And as I said, there just reasons came up why we didn't do other interviews. And then I never had an excuse to put them on the podcast. So here they are on the podcast. They are Tom Metzloff of Duke, who's a longtime professor there, and Don Chutkow of Cornell. And both have been absolutely wonderful hosts when IJers have been to both of those schools, including when I was talking about my book, but in other cases too. And so I wanted to sit them down both when I was there and ask them what their favorite circuit was and talk a bit about it. So Tom is going to discuss the Fifth Circuit, and Don is going to discuss the Seventh Circuit, which listeners know is also a favorite of mine. And I hope you enjoy them. And for now, thank you for listening. And thank you to Ben for coming on. And please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all other podcast platforms. And remember to get engaged. And stay tuned for Tom and Don. So we're here with Professor Thomas Metzloff of Duke University School of Law. And I'd like to know what he thinks about the circuit courts. Where did you clerk in the circuit courts?
Well, I clerked in the Fifth Circuit. So I was born and raised in Buffalo, New York, and spent all my life in the Northeast. And I found out there were these things called clerkships, and it sounded great. So I remember talking to my girlfriend at the time, then fiance and wife, still my wife, and said, "Hey, how about New Orleans?" And she goes, "Why?" It's like, I just think it'd be really different. And all of my friends were applying to the Second Circuit and the D.C. Circuit, and it's like that's not interesting. And to me, it was like, here's a chance to go someplace different. New Orleans, wouldn't that be amazing? So I was very fortunate to apply to and get a job with Robert Ainsworth, and he was very important on the Fifth Circuit. He actually was one of the main people who led the way to get the circuit split, because I was there in 1979 before it split up into the 11th and 5th Circuit.
Do you think it needed that split?
Oh, absolutely. I remember talking about with Judge Ainsworth. So early on, I think it was November of '79, they had an en banc hearing. And this was the first en banc hearing with the full complement of the Fifth Circuit judges. And Judge Ainsworth said, Tom, do you know that we're about to go into an en banc hearing? It's the same size as the original United States Senate. And they had to reconfigure the classroom with different tiers. So it was like this, a panel of 26 judges and lights so people couldn't interrupt at time. And he said, this is just ridiculous. And so a lot of people were very opposed to the split because the Fifth Circuit did all the hard work when it came to the desegregation. And some of those judges were vilified. And it's interesting, the great judges on the old Fifth Circuit were mainly Republicans who had been nominated by people like Eisenhower. So Elbridge Tuttle in Atlanta, John Brown, all these sort of folks were amazing judges who had to do unbelievable work as they did, district by district, state by state, to break down the barriers of desegregation. And that's one of the things that always appealed to me about the Fifth Circuit was that incredible history they had in civil rights.
So how's the Fifth Circuit different today? Obviously, it's more conservative than it used to be. Do you see some commonalities? What are the big differences other than the obvious?
I don't see many similarities because it just seems so different. I mean, this is now the court that is leading the way. I mean, a couple of years ago, it was like, the Supreme Court decides so many fewer cases now, and that's one of the things that just sort of I think about all the time. Why are they only doing 60 cases a year? The year I clerked on the Supreme Court, we had 142 cases with full oral argument, and they're down to less than half. And there were a couple of years where it was like, what's the number one circuit in terms of cert grants? The Ninth Circuit. And why did they grant them for? Grant to reverse, as we call it, because the Ninth Circuit was so liberal and out there. But this last term, a lot of cases from the Fifth Circuit, and it's become so conservative. They're kind of leading the way. It's kind of like they're teeing up issues, and it's going to be just fascinating to see if the Supreme Court sort of takes the lead of this very conservative now Fifth Circuit. But the thing about conservative is there's lots of flavors of that. And one of my favorite judges on the Fifth Circuit is Donnie Willett, in part because he was my student and research assistant. And he's a very libertarian judge, and he's written some very, very well-known sort of opinions out there. And I really do admire his jurisprudence and his approach. And there are other conservatives who, kind of not of the kind of ilk that I would resonate with very often. But the Fifth Circuit, it's I guess similar and still doing really interesting things.
So you talked about the Fifth Circuit and the split, and it was needed. Do you have any thoughts on the Ninth Circuit? If you care to give them your advice on whether they've been talking about splitting for decades and decades, of course, but they're even bigger than the old Fifth Circuit.
Oh, much bigger. And so I clerked with Justice White. Justice White, after he retired, chaired the committee to examine whether to split, and so he had the hearings with the Senate to split, and he concluded they needed to be split. The problem is if you don't split California, you don't achieve it because it's by itself so big. Although it needs to be split. I mean, the way they do it now with these sort of they have a Ninth Circuit A and a Ninth Circuit B, and they do the en banc hearings differently. I guess it depends really about how important collegiality is among a court. And the Fourth Circuit is something like 15 judges. Everybody I know there says, we know each other when we get together on panels. We have that. You get much beyond that. This idea of collegiality is really difficult. And I just don't think it can exist on the Ninth Circuit with the number of judges they have. It's kind of like, it reminds me of faculty meetings in some ways. So, we used to have faculty meetings with 25 people. That sort of works because but we're now up to like 50, and it's like, it's just not the same. I mean, and that's okay. But I think they need to split. But again, nobody's figured out how to do it.
So we don't have much time left, but I'd like to leave us with your best Fifth Circuit memory.
Well, the Fifth Circuit building I think is gorgeous, and it's right in downtown New Orleans. It's not in the French Quarter, but maybe my best memory of the Fifth Circuit was walking outside one day, and the district court's right next to it, and standing there with a lot of press around him was some guy named Muhammad Ali, who was being prosecuted for death dodging, and it's like, wow. And his case eventually went to the Supreme Court. So I don't know if that's a favorite memory, but it's certainly a memory. And then being in New Orleans, it's like pretty close there. It's a great place called Mother's where everybody would go to eat, and still a great place to go to get a po' boy and other things. So, what they say about New Orleans is true. It is a wonderful place for great food all over the place. And that's Joe Jainsworth was part of that. He was always kind of telling us, hey, have you tried this restaurant? Have you tried that restaurant? I was a little, this is not a favorite memory, maybe a least favorite memory. I had some friends who were clerking elsewhere on the Fifth Circuit. And so every month they'd come into town, like from Judge Goldberg's chambers in Texas. They'd come in and they'd say, Tom and my wife Nancy, you guys want to come out to dinner? We're going to Antoine's tonight. And it's like, you guys are on a per diem because you're traveling from out of town. I live here. I don't get a per diem. Thank you very much, but I can't go. But so those are not really Fifth Circuit things, but it's a little bit about what I remember from really fascinating years spent in New Orleans, which for me was different. It's culture shock. If you're from the Northeast, New Orleans is a very, very different place.
Well, thank you for your memories, and thank you everyone for listening.
Thanks.
So I'm here with Dawn Chutkow of Cornell University's School of Law, and she has kindly sat down with me to talk about her favorite circuit. So Dawn, what is your favorite circuit and why?
Well, what a great question. So first of all, I have to embarrass you and tell you that I'm delighted to be on the podcast because I am an actual subscriber and I listen. So,
a rarity.
Yes.
And we thank you.
So I'm hoping you don't drop that on the editing floor. All right. So my favorite circuit, I'm going to have to say the Seventh Circuit. And here are my reasons. Wisconsin, Illinois, Indiana. This is a quintessential, wonderful Midwestern institution in all of the best ways that you would use the term Midwestern. There are a lot of really bright judges on the circuit. They're incredibly hardworking. They take their work seriously. They are there's not a lot of drama. It's not a particularly flashy place. And so it is, for my mind at least, it's the great Midwestern court.
So one thing I've found about the Seventh Circuit in practicing there, the little that I have, is their staff attorneys are more on the ball than most law firms who get paid billable hours. They will call, if you make a mistake in filing, they will call you up within 5 minutes and tell you how to fix it. Have you had experience with the Seventh Circuit staff?
Yeah, so maybe not so much with the staff attorneys, but I'll tell you how I get to this sort of Midwestern, in the best sense, kind of court, is that, first of all, not a lot of backlog, and that has something to do with the staff attorneys. You can expect your case to be heard and heard pretty quickly. In terms of the lack of drama and the lack of flash, if you look at, so let's just look as a way of measuring this of the Supreme Court and how many times a circuit gets reversed. Now, I know the Supreme Court takes cases and they reverse on a regular basis, and that's part of the reason cases show up. But the Seventh Circuit on a regular basis is at the bottom of the reversal rate. I mean, they're down at around 60% since 2007, as opposed to being compared with the Ninth Circuit, for example, which is somewhere in the 80s. And if you can correct me, but I think last term the Ninth Circuit was at almost 100% reversal rate. So you don't see a lot of that out of the Seventh. They're just right down the center. They're not creating a lot of trouble. If you look at sort of cert grants, I think last term or the term before it was 5% of the docket came out of the Seventh Circuit. So it's a low drama circuit. And on your point about sort of the hardworking side, this goes into mine, not a flashy circuit. So the staff attorneys are a perfect example of this. But for example, they have a number of policies that you don't often see at other circuits that are quiet but are really interesting and effective. So the one I'm thinking of is every represented party gets scheduled for an oral argument. And that is, in a world in which we're moving away from oral arguments, we're moving away from published opinions, that is a sort of an outlier with respect to other circuits. I don't know if you were aware of that, but
Yeah, I've noticed even some pro se parties get oral argument at the Seventh Circuit.
right. And so the thing about this that's really great is twofold. One is young attorneys. I think you said you started at the Seventh Circuit and you've argued there. Young attorneys get an opportunity to sort of see what it's like to stand in front of a bench to make an oral argument. Do not play fast and loose with standing, because they are standing hawks and take it incredibly seriously. So they get that experience. But the other thing it does that I think is really positive is parties. It's not a black box where they go and get a case decided. Parties get to see the panel that's deciding their cases. They get to hear what the arguments look like. They get to hear what the points of contention might be. I think it's a wonderful way for parties in particular, for legitimacy of the court, to see who's making decisions and to feel like they're seen and heard. So that's a great example of the kind of things that they do just really quietly, that and without a lot of flash, that make it one of my favorite circuits.
So what is your favorite Seventh Circuit memory or anecdote, if you want to share it with us?
Yeah, there have been some great cases that have come out of the Seventh, in particular with Posner as judge. In particular, there were some issues with the oral argument, and I'm blanking on the case which dealt with same-sex marriage with Posner, is just classic, absolutely classic. Baskin, I think, might be the case. The other thing I like about it, so this is a sort of an ancillary kind of favorite sort of memory, is there's some really terrific judges there that have been there for a while, but it's a pretty young bench. I mean, since 2018, 7 new judges appointed, 4 Trump, 3 Biden, but it's still a pretty copacetic place. And they've got some older judges that have been there for a while that were rock stars. Posner's an example, Easterbrook's an example, right? Rovner's an example.
Bauer.
Yeah, Bauer, right. Actually, he married me, so he conducted the civil ceremony at my wedding. So, yeah. So I have a deep appreciation for him. But that aside, some of the younger judges are real superstars too. So, not saying I'm pulling this name out because it's a Cornell Law School alumnus, but this individual is Judge Amy St. Eve, who's one of our graduates. It really epitomizes, meticulous attention to the record. She came up from the district court. And to loop it back to my Midwestern sort of classic Midwestern institution, she gave a speech recently at Northwestern in which she was asked about sort of the 10 lessons she'd learned in her professional life. And she had a list of things that she'd learned. And the last one was, you can be really capable and good at your job, but it's important to be nice. How many times do you hear that from a federal judge? So that's why the Seventh Circuit ranks as my favorite.
When I was practicing in Chicago, St. Eve had just gone on the district court bench,
Yep.
and I probably had 50 status hearings before her, and she was always the epitome of a nice but serious judge.
Completely.
And very much appreciated her.
Good. Well, I'm glad that my claim is being supported by your evidence. So.
All right, Don. Thank you.
Well, you're very welcome.